here. Come on, people, start flooding in. This is a juicy story. I got no people so far. No likes, no people. I got full bars, so I know I'm live. Let's see if we'll get some people in. If nobody's in here. Oh, time to stand, hello, time to stand. Hey, now people. Hey, everybody. Hey, Langley. Hey, guys. I'm going to do a quick little update here. At least let everybody know, hey, I'm still out here doing stuff, even though I haven't posted. So we got 7 people in here. I think that's, oh, hold on, hold on. Well, oh boy. Well, someone tried to call me and I had to deal with that. But real quick, let me get into it so I can call that person back. I didn't want to be live very long. Thanks, Mike. Miss you guys too, seeing the feedback. But let me get into it. I'm here at the Butte County Superior Court here in Butte County. I've been covering a murder case, and then for those who don't know, that is violation of Penal Code 187. This is a almost 30-year-old murder case dating back to 1991 in November, and supposedly the person that I'm documenting in this case, I've actually gone to the jail and communicated with them to get, better understanding in their side of the story. But allegedly, this person chopped up and dismembered this woman in a bathtub and then disposed of the body. And now, after all this time, they're able to, I got a text message here, it kind of screwed up my train of thought. And after all this time, now they've arrested this person back in August of 2019 with the charges of murder, yet the body has never been found, and pretty much they're relying on witness statements and supposed evidence that's going to prove that this person disposed of the body and dismembered the body. So it's going to be interesting how they're going to prove that with no body, but the DNA does all sorts of things, so we'll have to see when we get to that. But the main reason I'm going live today is because I got kicked out of the courtroom, and not even before noon. And it started off before we even got in the courtroom. I asked the deputy, because he came out to everybody, I asked, can the media go in now? And he said, oh no, not yet. He was very angry. I could tell by his tone. Already, just asked a simple question, and I got met with, no, not yet. And, okay, no problem. Go back to my paperwork. And then, as I'm going through my paperwork, he comes at me again. What are you here for? And I said, I filed a media request. Are you familiar with the MC500 and the MC510? And, oh my God, that just slammed the brakes on everything there. I just said something in code that had completely bamboozled him. So he explains, well, who are you here for? And I said, I filed a media request, MC500 and the MC510. I'm here with Cameraman Investigations, and I gave him the case I'm here to cover. And I guess that satisfied him, because he got on his radio and they were looking for somebody else. And after they identified that person, everybody was allowed to come into the courtroom. So I get in there, set up my equipment. We get to the person I'm here to hear the case for. The judge comes out. We go through the media request. And keep in mind, I filed at least 3 or 4 media requests. Yes, Mike. Yes, we got to talk very slow. 3 or 4 media requests before this preliminary hearing date, but all these other dates have been just continuances on the case, so it's not really big, but today was the big one, if you will. And I got in there, the judge acknowledged my media request. He also acknowledged a letter I sent him about the issues I've been having with this media request. And as usual, his public defender, who is completely against me, gets up, explains again that he has concerns of privacy, but because I sent a letter to the judge, I finally got the public defender to admit what privacy concerns he had. because I had addressed him outside in the courtroom previously about this, and he never gave a definite answer. But today, his reason of privacy is that he does not want images of his client's face shown. Yet, the way I found out about this case was a press release from the sheriff's department with his own mugshot. And his mugshot is no different than the way he looks now. If you put him up side by side, the only difference is that in his mugshot, he has his hair in a little bun, and now he just has his hair down. But it's clearly the same person. It's not like he's had a complete, makeover of his face. So that's his reason of privacy, and I should have objected to the judge and said, "Objection, Your Honor," and explained that, but I wasn't going to risk getting a PC 166, contempt charge, because, they're very anal about that. And so, no biggie. I'm going to, we can always use our First Amendment right anyways. And so I decided to take notes. And so as I'm taking notes, this is during, they have one of their witnesses come up to testify. Now, what I don't believe the defense, his public defender and the people know, the defendant knows, because I've been contacting him through the jail through visitation and by mail, but I have a complete copy of the arrest warrant affidavit for him that was made back in 2016 with this supposed witness statements that are on stand right now testifying. And as I'm going through this, testimony and taking notes, he admits to something that he did not admit to in his original questioning in that arrest warrant affidavit, and it completely contradicts what he stated. No time to stand. I am the only media that's been fighting to document this case. The first day I went down there, he didn't have a public defender, which he should have had a public defender. I even talked to him about this in the jail. The first day he didn't have a public defender, so they continued it to the 2 days later until he had a public defender. But all the media, the mainstream media, KCRA, NBC, Fox, they were all here. But the next day when I came back with the media request for the day that he would have a public defender, I was the only media there. Everybody else had gone. And so, exactly, David. So I've been the only media fighting this case. And back to what I was saying, so he admits, I don't want to go into too much detail, but he admits to something that he completely contradicts what he stated, and they won't, as the defendant put it, time to stand, he wants me to be his media guy, so if they ever do decide to wake up, they'll have to come to me for all the answers. I will give you the case number, everybody, at the end of this. I will type it if I can put it in the chat, or I will say it out loud if anybody wants to look it up themselves. But this witness admitted to stuff that completely contradicts what he said in the arrest warrant. And when he said this, I gasped a little bit and sort of, caught myself. And because, you can't be making noise in the courtroom or you'll be PC 166 subsection 3. My friend Nicholas Wildstar knows very well about that. But, oh my God, the deputy got up. He came over. He was steaming angry at me. And he gets up and he leans in my face as I'm sitting down. "If you have another outburst like that again, you are out of here, and I will arrest you. You understand me? You're talking to me now." And this guy, I don't know if he woke up on the wrong side of the bed this morning, his girlfriend left him, he's not getting any at home, or what his problem is, but he was just so angry. And I told him, well, I didn't know that he was going to admit to something that, and later on, even the public defender catches him in a lie, because at the beginning of the cross-examination, the public defender asks, "Well, have you taken any drugs or alcohol?" And the guy said, "Well, not until after this, that's when it started." And because he asked him, "Well, do you have a problem with it?" Well, I wouldn't say problem, but he didn't want to, flat out admit that he uses them. I mean, he uses them essentially, but he's not like a drug addict or something. The way I saw it is the public defender was trying to trying to allude to that his memory not being so well because of drug or alcohol problems. But as we go later on, the public defender asked, well, it says stated that, during when this incident happened. Yeah, exactly, Nasty Nathaniel, exactly, good one. But he stated when this happened that he told investigators, supposedly, I don't have this in my arrest warrant, but again, this guy has been talking to detectives for a course of 30 years. But as he's talking to the guy on the stand, he asks him, well, it says right here, the night in question, before things happened, you went into the house and took a 12-pack of beer and an eighth of marijuana, or baggie of marijuana, which you claim to be an eighth. And he said on the stand that he denied doing that. But as the public defender pushed him forward, as he said, well, I just want to determine when you lied here. Because he proved that he was lying with the evidence that he had, the statements that he made, and then he wanted to claim that he did not do any drugs or alcohol until after this so-called incident, which has caused him to have his problems in life, because he's explaining that he's having nightmares and whatnot, and which could be true. I mean, what's described is a very traumatic experience, but to then say, as you're talking to the people, that you do not do any drugs or alcohol, but then when cross-examined by the defendant and with statements that you made that you did take drug and alcohol on the night in question, that kind of contradicts your story and creates a reasonable doubt. And so that's why I was kind of gassed at the beginning there with that was the admitting of doing, participating in something that contradicts the warrant. But as the public defender's doing all this, exposing his lies, I'm writing all of this down and, occasionally shaking my head because I know it's a lie. Because I'm taking notes and, just in disbelief, and I'm writing these things that I know are contradicting other things, and I'm just shaking my head in just disbelief. And of course, keep in mind, people, I'm in the front row, but I'm not, I try and be closer to the back corner. So this was so I could set up my camera, but my media request was denied. But so it's not a big, not a big issue. But I'm in the corner, and later we go to recess, the morning recess for 15 minutes. And when I come back, the deputy got in my face again as soon as I opened the door, and he said, "Well, let's be straight about this. The head bobbing." And I'm like, head bobbing? What do you mean head bobbing? And he's explaining, I didn't question him, but he's explaining the head bobbing and the motions are distracting the judge and the defendant. And yet the whole time the judge has never said anything about this to me. It's his courtroom. If anything, I want him to find me in contempt if I'm doing something wrong. But yet this deputy says I'm head bobbing, and I'm sorry, when I heard head bobbing, this is head bobbing. I mean, this is shaking your head, no. So let's be clear on our definitions. It's like he wanted to make me out like I'm in there jiving and weaving and singing and dancing, and I'm just shaking my head no, but apparently that's head bobbing. I'm a bobblehead. So he confronts me about this, and I said, fine, because I don't want to argue with him anymore because this is an all-day matter. And as he walked away, I told him, well, I will sit where you can see me. And I went around the row, and there was a row, and of course, I didn't notice that there was two little chairs of this row of 6 chairs, and there's a little chair right here. And I came around the row because I wanted the row furthest to the wall because the deputy, and there, right there, ladies and gentlemen, there's Lieutenant Liar. Lieutenant Liar. He went out and construed a story afterwards, but I'll get into that in a minute. And he works in the DA's office. He's a DA's investigator. And so I go in there, and there's a row in front of me, and that's the row that's apparently closed. But I'm like, well, if I'm going to be sitting closest to the front, I want him to see me, so there's no, misconstruing of what I'm doing. And then there's a row in front of me, so I just step over and sit in that chair, and it's the furthest to the wall. And he gets up and he gets all angry. "Oh, you sat in the row that's closed. Get out of here. Get out. You're out of the courtroom." All angry, and "Oh, I will, time to stand. I will in a minute." And orders me out. And he's, "Oh, you sit in the row that's closed." And I said, "I didn't know it's closed. You've been moving the chairs." Because when the public defenders were sitting down for, because other cases were called, he would pull these chairs from the back and sit them in the front. But yet they have signs up that indicate that you cannot talk to any inmates or you'll be arrested. But they have no sign indications to indicate that you cannot sit in a row that's closest to the defendant. That's why the row was closed. But how does that make any sense? This is a public courtroom where people can sit. This is not like a special area for jury or defenders. It's not in the gallows. This is seating where any member of the public can seat. But apparently, because there's these two chairs stacked to each other there, that makes it closed, even though there's no sign or caution cone or anything like that. And that's when he ordered me out of the courtroom. But we'll see if I can go in later this afternoon after afternoon recess. This is not my first being kicked out of the courtroom. So we'll see if we can go in after lunch. But I also plan to speak at the Board of Supervisors today about this deputy's behavior. Because in the media request, I've even put, because they have a section that says, please put any anticipated problems or special requests. And under anticipated problems, this is one of the anticipated problems I put, that people unaware of the MC500, including but not limited to court personnel, may try to disrupt the filming or try to prevent freedom of the press. Because regardless of the media request being approved or not, I have a right to freedom of the press. And I put this as a potential problem to the judge, that court personnel will try and use prior restraint to prevent me from documenting this matter of public interest. And it's clearly been proven today. Oh yes, I will be writing a letter to this judge. But the problem is this judge today, they have a judge just to preside over the special preliminary hearing. The judge that is handling the case, I guess, after the preliminary hearing is the one I need to do the next media request to, as the judge put it in the, I wasn't going to argue with him, but the Judge Benson, he's the one presiding over the special preliminary hearing today. He said, well, this is for Mr. Deems. I'm not Mr. Deems, I'm Mr. Benson. And I didn't want to be rude, but I'm like, yeah, I know that, Your Honor. It says they're right on your plaque, but the media request is forever who is going to be presiding over that case that day, and that is you. So you are in control of whether or not I'm going to be filming in this courtroom during this preliminary hearing today, not whatever happens afterwards that Deems is in control of. So even the judge sort of didn't want to address it and, act like, oh, it's not my case, not my courtroom, not my problem. But yeah, it is your case, it is your courtroom, it is your problem. And we're here to resolve these matters. And so that's pretty much why I got kicked out of the courtroom. Now, there was an incident with the public defender, which I'm now going to talk about, Mr. Kevin Sears, who is a public defender of Butte County. Now, the way the public defender's office works in Butte County is that there's not a set office for public defenders. Like, I'll give an example. In Orange County, they have an office of public defender in Santa Ana. But up here, all the public defenders are part of a collective. And I guess it works is I never got a sure answer on this when I inquired about it to the so-called head of public defenders. But apparently, I guess your name is just like picked out of a hat, and if you're selected, you get assigned to that case. There's no separate office here at the county administration. I mean, the district attorney's office is up there on the second floor, but not a public defender's office. So I guess this is how Mr. Sear gets assigned to this case. His name gets picked out of a hat. Bada bing, you're assigned. So I tried to reach out to him multiple times before this preliminary hearing date. Well, primarily the whole issue before these court dates with continuance is because originally this preliminary hearing was supposed to be on the 8th or 10th of December. I'll have to look back at my notes. But it was continued today till February 11th, 2020, because the people's DNA expert would not be able to be there on the date that they originally wanted in January, because the previous preliminary hearing date in December couldn't be held because evidence transferred to the public defender, these videos, some of the files were corrupted. I don't know how, but they were corrupted and he couldn't view those files. So it got moved to a January date, and then the people complained that, oh, our DNA expert's not going to be here, so we need to go to February. And so it got moved to February, but before this original preliminary hearing date, I tried to reach out to him twice to see if privacy would be an issue, and he never responded back to me. So after that preliminary hearing, I've been visiting. Yes, the defendant wants me to cover the case. He is not opposed to media coverage. So after this preliminary hearing date in January, after New Year's, I started going down to the jail, which is over there, on Saturdays and Sundays, doing visitation with him. And I found out that not only did he tell the public defender to tell me to come visit him in jail, he's told the public defender he wants me to film and do media coverage because he believes it'll help his case. During one of the calls, because I think this was after our 4th or 5th visit, he called his public defender, because he wanted me to go in and view the files pertaining to this case to help further my investigation. And he told him that he wants Cameraman Investigations to have full access to discovery. And when he called, his secretary picked up and claimed that Mr. Sears was not in. But a few minutes after that call, while in jail, he got called back from Mr. Sears, saying, oh, I don't know why my secretary said I wasn't in, but I'm in. What do you want to talk about? And he explained that he wants me to come in and view these files, and I don't believe I can get this recording because it would be considered attorney-client privilege, even though all the calls in and out of the jail are monitored and recorded. Apparently during this conversation, Mr. Sears told my defendant that he will not be releasing anything to me. I am crazy. And I tried to argue constitutional law with him the day outside of court when I tried to get an answer out of him about what is so, private, what privacy issues are going to be, what's the issue? And he corrected me, saying, oh, I think you misheard me. I think you meant to say identity issues. And I said, well, it's relating to the same issue. No, they're two completely separate issues, as Mr. Sears told me. And I said, well, they're not really, because the only reason I could see you bringing up identity being an issue is that you're concerned that somebody's privacy is going to be exposed by having to appear and testify or present evidence in a public courtroom that everybody has the right to come in and view, regardless if they have a camera or not. So what is the difference in if I'm recording or someone coming in with their eyes and ears and documents it with their brain? Because regardless if I record or not, someone can go out and tell, hey, so-and-so, that so-and-so came to court today and I saw him get up on the stand and say this and this and that, because it's a public courtroom. And for that, he didn't really have any answer. And because he stood there silent, I continued the conversation, and I told him, it makes the media's job hard when you prior restrain, because I can't get up and contest because I might be PC 166. And before I could finish that statement, he cut me off. He said, oh, no, my job isn't to make the media's job hard. It's to defend my client. And that's a fair statement. But the way he feels that he has to defend his client is to use prior restraint on the media, and that I do not agree with. And so before this hearing date today, a couple weeks ago, I went over to Mr. Sears' office in Chico, downtown Chico. And keep in mind, I've recorded in his office 2 times prior to this. Oh yeah, I've gone in there myself. One of the dates I actually made a sketch myself, and that's allowed. There was no problems with that. I was allowed to make my own sketches, but it's really hard work, and I found I can take notes a lot faster than I can making a composite sketch. But I went to Mr. Sears' office this time and asked, well, can I come and view, I'm here to view the files. And his secretary had no clue about what I was talking about, and she noticed that I was recording with my body camera, and she said, oh, are you recording right now? And I told her yes. She asked me to turn it off. I told her no, and I explained that Mr. Sears is a public employee when he's acting in the course of his official duties as a public defender for the county of Butte, and so that gives me the right to record him under Penal Code 148G. And also in that Penal Code 148G, it says that if a person has the right to be in a place where they have the right to be, it cannot be considered a crime if they're recording. So if I'm in a public lobby where I have the right to be, that other members of the public have the right to be, then I can record in there, and it's not a crime. Now, if I went behind his closed door into where all the secretaries were and recording, yeah, that might be considered a violation, because that's not an area that's open and entitled to the public. But when I explained this to her, the law, she said, well, I'll just let Mr. Sears deal with that. And I must commend, she professionally handled herself and did not escalate the situation. She just took it for what it is and facilitated my needs. And that was finding out that he was not in, and I would have to leave a message, and I left a message, and he never contacted me before this date today. But instead of addressing my issue of viewing the files today, when I got into the courtroom, this is after having our little shit show with the deputy outside the courtroom of him not understanding the media request, demanding who I was there to film, and the other nonsense. I get in, and as I'm setting up my equipment, Mr. Sears approaches me, and he said, oh, let me get some understanding here about this filming. That's private property, and you cannot go in there and film. And I tried to explain the law to him, 148G, and he continued to get louder and belligerent with me, and he told me, no, that's private property, you cannot go in there and film, that is private property. And I tried to explain to him under 148G that he is a public employee and I have a right to record in the public lobbies. And I also told him too that I've already recorded in his lobby multiple times, and I told him, what are we going to do about it? Because, I've already recorded, so essentially, come and arrest me. And he told me, well, you're not allowed to anymore. And I told him, well, can I get something in writing then if you're going to claim this? No, this is your warning. I have warned you. And so after that, as we're, having this unprofessional display in the courtroom, that's when the deputy comes over, and then he threatens me with arrest because I'm making a scene, even though the public defender approached me and threatened me and tried to violate the law by claiming that I have no right to record in a place where I have a right to record under penal code. Exactly. Thank you. See, at least somebody here knows what freedom of speech is. The First Amendment. Freedom of the press, freedom of speech, freedom of religion, freedom of association. And time to stand, yeah, I would give you the phone number to his office, but I don't want to call Flood and have him be even more bitchy than he already is, because he's clearly a tyrant. I've dealt with public defenders like him before, so it doesn't surprise me that he's totally opposed to the media and very ignorant of the law. But I guess we're just going to have to do some more filming in there and see what comes of that. But he got very belligerent with me, and he started making a scene, and then the deputy came over and starts to threatens me with arrest. He said, if you be contemptuous and loud and cause a scene, you will be out of here, and I will arrest you. You're talking to me now. and got all threatening. And both of these gentlemen, if the judge was there, this would be considered a violation of Penal Code 166 subsection 3, because you cannot make a loud noise that causes a disturbance in a courtroom while court is in session. But because the judge was not in there at that point, there was no proceedings in session, so they could technically, I believe, get away with this. But yet they had the nerve, the bailiff had the nerve to come over and threaten me with arrest when he clearly saw the public defender come over to my side of the courtroom, lean over the counter, and began threatening me with trespassing. And if he wants to trespass me, that's why I told him, send me something in writing, because that way, under 602, he can prove that he trespassed me. But all he said in the courtroom is that no filming. There was no definition of trespassing. He didn't say trespassing, he said no filming, it's private property. So, well, ladies and gentlemen, I got some people coming out that I got to speak to, I'm going to go ahead and kill it here, and hopefully I will be able to come back later into the courtroom. If not, I'll probably be giving you an update again around 4 o'clock, because court just let out. It's 11:55. I got to get going. I got some witnesses to ask some questions to. Well, not really witnesses pertaining to the trial, but people that were inside the courtroom that I know that didn't get removed. So anyways, just checking in. Gave you a quick update. Oh, in the case number, real quick before I forget, in the case number, if anybody wants to look this up on the website there, Butte County Superior Court, the case number is 1919 CF 05320. Again, 19 CF 05320.